And of course, the first sentence reads, "Thank you for your request for hearing before an administrative law judge." It goes on to explain about the 75-day scheduling. And essentially, this letter is your receipt that your request for hearing has made a safe journey from the field office to the hearing office. And so with this packet are several forms that we're going to go over one by one and indicate what they mean and what to do with them. Okay, so the first form that they put in here is called an objection to appearance by video hearing. And we're going to talk about that in another module more in-depthly, but at this point, leave it alone. That form is for us to complete and send in, and you can read it, but we don't want you doing anything with it. From there, they go into what happens next, video hearing, the benefits of it, etc. And there's another form that probably looks familiar to you. It's called a authorization to disclose, also known as the SSA 827. If you look at the bottom left of the form, it's got a form number, and that 827 is for the hearing office to obtain medical records from your treating sources. So our recommendation, of course, is to sign and date that. They give you an envelope, send that back, you'll be good to go. And of course, the next form is called a claimant's recent medical treatment, where they're asking you in a column. One column reads doctors' names, the other column reads addresses and dates, etc. And of course, if you're diligently updating your visit summaries on StatusStar, we already have all this information. We can simply print those screens, stick it on a barcode, send it in, and you're done. So it's important that you are completing these as you're finishing treatment. And the next form over that is called claimant's medications. Once again, this is all captured for you in StatusStar, so you're not filling the same information on different government forms, asking you the same information 10 different ways, which is very common dealing with the U.S. government. So really, we should be amending the onset for only a couple of specific reasons. One of them is that your medical condition had dramatically degraded between the time you last worked and the time of your hearing, and now we can point somewhere in the medical records where, unlike when you last worked, a test came back or you had a setback of some kind, and we amend the onset to that date. Another reason is if you had returned to work, you try to go back to work and it's called an unsuccessful work attempt. But of course, if you maintained work for more than 6 months, the regulations indicate that you can no longer consider that unsuccessful if it was greater than 6 months. Another reason would be you change grids. You age between the time you last worked and now what you're hearing. You might have been 54 when you went out of work, and by the time sometime between then and now, you've turned 55, and the grid rule applies that makes it more favorable for you to get approved. And so those are sort of the limited reasons we would amend the onset date, but that's what it means. What's the practical implication of it? Well, okay, here's another one. I see this a lot and it makes me laugh. A lot of times employers make these fancy titles, or you might have thought you were a supervisor, but you got to ask yourself, were you involved in budgeting? Did you do the scheduling? Did people call in sick to you? These are the kind of things that are more likely that you were a supervisor, okay? And so I see a lot of work history reports where the individual was a supervisor, and then when I ask them about it, I'm like, no, that was just some fancy title. So very important, those are the issues, those are the kind of tasks that you've done, and if you did those tasks, you're more likely to be considered a supervisor.